Welcome and thank you for joining part 3 of Seyfarth's micro webinar series, Hot Topics in Employment Law for Massachusetts Healthcare Organizations. This installment of the series will focus on ADA Title III and public accommodation. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature in WebEx. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Michael Steinberg. Michael, you may begin.
Thank you, David, and good afternoon to everybody joining us, or good morning if it's still morning, wherever you happen to be viewing this webinar. My name is Michael Steinberg. I'm an associate in the Boston office here at Seyfarth Shaw. I have the pleasure to be joined by my colleague Lotus Cannon, who is also a member of Seyfarth Shaw's Title III defense team, and she sits in New York, but is no stranger to Massachusetts, and we're very pleased to have her. So today's installment of our series on hot topics in employment law, somewhat counterintuitively, is not about the obligations of employers as employers, but rather employers when they are places of public accommodation, and the obligations that they owe to members of the public who enter to access the goods and services available, whether those be digital or physical in nature. So moving to the next slide, a quick rundown of today's agenda. First, we're just going to level set for those who may be somewhat less familiar with this area, and I'm going to give an overview of the legal landscape, what the obligations are under Title III of the ADA, as well as two statutes that have particular applicability to healthcare employers, the Rehabilitation Act and Section 1557 of the Affordable Care Act. Then I'm going to move into a discussion of one of the real hot topics in the world of accessibility law, and that is the accessibility of digital assets like websites, mobile apps, and again, of particular interest to many healthcare employers, telehealth platforms. Then my friend Lotus is going to lead a discussion of a different set of requirements under the ADA, auxiliary aids and services to facilitate effective communication. And lastly, a fan favorite here in the world of ADA Title III law, service animals and what obligations arise when a member of the public is accompanied by a service animal. So moving on to the next slide, we're now going to quickly cover the legal landscape. So the Americans with Disabilities Act is a civil rights law. It's been on the books for over 30 years now. It was enacted in 1990. And it covers 5 different areas, one of which, Title I, is employment. Title II governs state and local governmental entities. Title III governs public accommodations. And Title IV governs telecommunications. And also under Title II, public transportation agencies are covered as well. Now, today's focus, as I mentioned earlier, is not on employment in Title I, it's on Title III. But I will say at the outset that we don't necessarily want you to walk away from this thinking that you learn nothing of value to an entity as an employer. The issues that we're going to discuss, in particular, making digital tools and software, websites accessible, how to handle service animal requests, how to facilitate effective communication. Those are areas that employers need to be thinking about as well, with respect to their employees who have disabilities. We know, especially in the world of healthcare, that healthcare employers operate in employees are using, for example, digital tools all the time. They may need to use software, for example, to access electronic health records. And so the same accessibility issues that we're going to be talking about here, applicable to places of public accommodation, certainly have great relevance to healthcare employers as well. And before I move on, one shameless plug for the ADA Title III blog that our firm maintains. It's very active, and the presenters here today, again, shamelessly have contributed content to it. It's a frequently updated blog that will give you ongoing insights and sort of thought analysis around the latest developments in this area of the law. It's ADA Title III, lowercase Roman numeral I, .com. So we would urge you to check that out. If it feels like you only got a little bite-sized portion today, you can keep getting little bite-sized portions on the blog. So if we can go to the next slide. There are three essential obligations under Title III of the ADA. Number one, physical facilities must be, in an architectural sense, accessible to people with disabilities, i.e., again, members of the public. And importantly, not only do they need to be constructed in a manner that is accessible and complies with the accessibility guidelines that are promulgated under the ADA, but they also have to be maintained so that they can be accessible to people with disabilities. For example, it's very nice if a facility provides accessible parking spaces to people with disabilities, but if during a cold New England winter, for example, snow accumulates and the parking space is filled with snow, well, the facility has a duty to clear that snow so that the space is available. Likewise, it's very important to provide a ramp that is has the proper dimensions and sloping for people with disabilities to enter a facility. But if that ramp is in disrepair, then it doesn't really do any good for somebody who has a mobility issue and may actually be dangerous. So maintenance of facilities is important too. Number two, places of public accommodation have to make reasonable modifications to policies, practices, and procedures when necessary to ensure equal access to the goods and services provided to persons with disabilities. Now, this is a very, almost a deceptively broad obligation. It sweeps in a lot of business practices that facilities may not even realize have to be examined in light of an affirmative obligation to make changes when necessary, absent an undue hardship or a fundamental alteration of the business. So one such example is sometimes facilities, even healthcare facilities, have to make modifications to whatever their general policies or practices may be to allow service animals to enter the facility. And this is something that Lotus is going to cover much later. That's an example of a general practice or policy that may need to be modified to accommodate people with disabilities. Lastly, places of public accommodation have to facilitate effective communication with persons with disabilities. And that can mean any number of things. And Lotus is going to talk more about that later in the presentation as well. That could mean an ASL interpreter, for example, for somebody who communicates in that fashion. It may mean providing materials in Braille for people who are blind or have other visual disabilities. The point is, it may also entail taking longer or providing alternative ways of explaining things, communicating information to people with intellectual disabilities. So ensuring effective communication is also a fairly broad category, but it's really important, especially for healthcare entities that are, well, welcoming patients, people who are obtaining medical care, are engaging in complex and layered communications about that care. And one of the ways that businesses have to do that is to provide auxiliary aids and services to facilitate that communication. An ASL interpreter is an example of such an auxiliary aid or service. Another potential way in which a business may have to facilitate effective communication is by providing accessible websites or mobile applications to the extent that those are made available to members of the public, to consumers. So we're going to talk about that in the next section of this presentation. Now, under Title III, there are remedies that vary based on whether you have a private lawsuit or whether you're looking at a DOJ enforcement action. And as you'll see here, you'd rather be facing, in many ways, a private lawsuit than a DOJ enforcement action. Private parties can only obtain under Title III of the ADA injunctive relief, as well as attorney's fees and costs. But monetary damages, compensatory damages, emotional distress damages, punitive damages, those are not available under Title III of the ADA. However, if you're looking at a DOJ enforcement action, the law provides for civil monetary penalties of, I expect everybody to memorize this number, $111,000 and $111,614 for a first violation, and $223,229 for a subsequent violation. Highly specific. Federal law allows for these penalties to keep up with inflation, so that's why the numbers are oddly specific. In a DOJ enforcement action, DOJ can also seek damages on behalf of one or more aggrieved plaintiffs or aggrieved parties who are not plaintiffs in the action, and injunctive relief. So DOJ enforcement has is very robust. If we can move to the next slide, please. Okay, so what is it? Who is covered under Title III of the ADA? Well, as you can see there, it's essentially a business, private business, that's open to the public to provide goods or services. And of relevance here, you'll see in bold blue, the professional offices of healthcare providers and hospitals are explicitly enumerated as covered entities in the statute. So there's very little question that most healthcare employers, if not virtually all, are going to be subject to Title III of the ADA as a place of public accommodation. But increasingly, the world of healthcare is evolving just like the rest of the world, and businesses are increasingly moving to provide their services primarily or exclusively online. And so you'll see there's a bullet at the bottom here, must it be a physical place? That's a sort of an open question in the world of Title III law, and courts have gone different ways on this. So I'll move to the next slide. Now, there's another statute I mentioned at the beginning, the Rehabilitation Act, Section 504 in particular. And this covers programs or activities that receive federal funds. So healthcare facilities and organizations are typically going to be covered under Section 504 of the Rehabilitation Act by virtue of, for example, receipt of federal health insurance funding, Medicare, Medicaid, these sorts of programs. Now, unlike Title III, money damages are available under the Rehabilitation Act, but with some limitations. No punitive damages are available. The Supreme Court recently decided that emotional distress damages are also not available in a Section 504 action. And unlike an ADA Title III claim, in order to at least get money damages under Section 504, there has to be a showing of intentional discrimination. So a good faith effort that fails is not going to be something that allows for recovery of money damages under Section 504. In addition, Section 504, as we just discussed, does provide for money damages. Even if there is no Section 504 claim, though, an ADA Title III claim, you'll often see it in conjunction with a state public accommodations claim. In Massachusetts, that's General Laws, Chapter 272, Section 98. Those laws are almost always enforceable, in the same manner as employment discrimination claims, and allow for recovery of damages, all manner of damages, emotional distress damages, compensatory damages, punitive damages. They allow for injunctive relief. So even though Title III of the ADA does have some limits on remedies, and so does Section 504, your state law claim can bring in a lot of other remedies. And that's very popular these days for the plaintiff's bar to bring a Title III claim and then add a companion state law claim based on the same facts. All right, so moving on to the next slide here. Now, there is, as many of you are probably familiar, a law called the Affordable Care Act, and Section 1557 explicitly prohibits a variety of different kinds of discrimination that were already unlawful under federal law, and focuses on healthcare programs and activities as subject to these prohibitions, right? So among other things, Section 1557 incorporates the Rehabilitation Act's prohibition on disability discrimination. So just like most healthcare entities are going to be subject to Section 504, they're also going to be subject to Section 1557 of the Affordable Care Act. And this means that for an entity that's principally engaged in the business of providing healthcare, all of the operations of that entity, if it receives federal funds, are going to be subject to the anti-discrimination prohibitions of Section 1557. And even for entities that are not principally engaged in the provision of healthcare, the law still applies to the extent that there is a healthcare program or activity being operated that does receive federal funds. So it's, in that sense, the coverage is even broader than Section 504 of the Rehabilitation Act. And pertinent to the discussion of web accessibility that we're about to dive into, Section 1557, pretty explicitly requires that programs or activities in healthcare that are provided by electronic means, electronic information or communication technology, requires that those be accessible. So there's a real web content accessibility is of particular relevance to healthcare employers. All right, so shall we move on to the next slide? As promised, now we're going to talk about accessibility of websites and mobile apps. This is the sort of, this is the hot topic. This is the really, this litigation in the Title III area has exploded. And we're seeing tons of lawsuits, especially in New York, where Lotus is, in California, but we also have seen quite a few of them here in Massachusetts. So let's just step back for a minute and ask the basic question: what does it even mean for a website or a mobile app to be accessible? A sort of lengthy technical discussion of the performance criteria for coding a website in a way that is accessible to people with disabilities is beyond the scope of this webinar. But at a high level, an accessible website is one that can be accessed and used by people with various types of disabilities. So often these cases are brought by blind individuals who need to use a screen reader in order to navigate a website. A screen reader is something, it's a software that reads what's on a screen to a person who's blind or may have low vision, so that they can access the website and use it in the same way as a sighted person. So things like an image that a person wouldn't be able to see. The screen reader, where the website is properly coded with alt text for that image, will declare, right, the description of the image, so that the person with the disability understands what the image is. Having form fields that are properly labeled so that a person using a screen reader knows what they are. Proper use of headings so that a person using a screen reader can easily navigate to different parts of a web page or a website. People with mobility issues, and also people who are blind may sometimes, not use a mouse to navigate a web page. And so making sure that there's keyboard only access. Likewise, audio descriptions for videos. For people who are deaf or hard of hearing, typically these claims arise. The complaints relate to not lack of captioning for audio content. So you'll see that there are all different, kinds of disabilities that are at issue here, because there is a variety of disabilities out there in the world. Moving on to the next slide. Okay, so I'm not going to spend a lot of time on this, but right now, the guidelines that are de facto the standard for web content accessibility are what are called WCAG, or the Web Content Accessibility Guidelines. They're promulgated by something called the World Wide Web Consortium, which is sort of a globally recognized voluntary consensus set of standards. These are not, these do not appear in any statute or regulation under Title III of the ADA, but in cases where the DOJ has entered into consent decrees with private parties, these are typically the standards that parties have agreed to. And these are the standards that, again, as a practical matter, sort of chart the course for what constitutes an accessible website or app. So moving on to the next slide. A quick note here for our healthcare employers that mobile apps are going to be need to be accessible in the same way as websites. So I'm seeing that we're very short on time here. We have other topics to cover. So if we could skip through, the bottom line is that there is an ongoing effort on the part of both regulated parties and the disabled community to get DOJ to regulate, to issue regulations that adopt standards for web content accessibility. And all I can say at this point is, as of this month, we expect the Biden administration to issue a notice of proposed rulemaking under Title II of the ADA for web accessibility. And Title II governs state and local governments. So although that's not Title III regulation, it is going to be very pertinent. We encourage all of the interested parties to participate in that rulemaking process when it comes out, because it's going to inform the Title III rulemaking process. And with that, I'm going to turn the presentation over to Lotus, and I apologize for running long on my time.
No worries. We will breeze through this. Let's see. If we could just turn the slide over to auxiliary aids and services. So as Michael noted in the introduction, one of the requirements for public places of public accommodation, including most if not all healthcare organizations, is to provide effective communication. There we are. Next slide. Thank you. Is to provide effective communication with people with disabilities. Now, how do you do this? You essentially have to provide alternative means of communicating with people with disabilities, whether that is a visual disability, a hearing disability, or a speech disability, in a manner that is effective and that the individual will understand. So, as Michael noted earlier, this is particularly important in the healthcare context when you're thinking about interactions that are going on between patients and their medical providers. The patient needs to be able to effectively communicate with their provider. The provider needs to be able to effectively communicate information to the patient in the way that the patient understands, and they need to be able to have, some ease of conversation. Okay, there are two, limitations to this requirement. The first is that you do not need to fundamentally alter the nature of the goods, services, or facilities that you provide. Okay, and the second one is that you do not have to provide anything that would be an undue burden on the business. This factor depends on the quantity of resources that the business has. So, if you have plenty of resources, this can be a pretty high bar to meet to demonstrate that something would be an undue burden. Now, imagine that an individual with a disability makes a request for an auxiliary aid or service to be provided that is not reasonable by these, two standards. If you do not need to provide that particular requested auxiliary aid or service, you still have the burden to provide an alternative means of communicating that would still be effective. We're going to run through some examples on the next slide. Okay, so what are some examples of auxiliary aids or services that you can provide in order to effectively communicate with individuals with disabilities? If the individual is deaf or has a hearing disability, you want to be thinking about providing content in a visual format. So for example, written materials. You may want to provide an ASL interpreter, as Michael noted earlier. If the individual has a visual impairment, you might, want to provide that content in an audible format. For instance, an audio recording or having a qualified reader, or an tactile format such as Braille. And if you're serving an individual with a speech disability, these are some examples of some technologies and devices that can assist with communication. In the context of telehealth and websites, as Michael covered, this would include providing accessible electronic and information technology. You would want to make sure that your website is accessible to individuals with visual disabilities by ensuring that it's compatible with screen reader technology. You want to make sure that you're providing closed captioning for your videos for individuals who are deaf. Next slide, please. Okay, these are just some more examples. I think we've covered most of these already. You might have individuals who are low vision, and you may assist them by providing large print copies of written materials. Next slide. Thank you. All right, so these are some requirements that you want to be thinking about in terms of whether an auxiliary aid or service is providing effective communication. You want to make sure that the communication is timely, that it's provided in a way that protects the privacy and independence of the person with a disability. The next factor that's very important in the healthcare context is that the method that you use is going to vary on the context. So it's going to vary on the nature of what you're communicating, on the importance of the information, on the complexity of the information. So when you're thinking about, a medical provider communicating very important, healthcare information to a patient, something that, a method that's more informal, such as gesturing or exchanging of notes, is probably not going to cut it. You're going to want to provide something that is a little more complex, such as, providing a qualified ASL interpreter. Okay, the next factor that you have to consider is the individual's preferred method. So, while you have the ultimate decision-making power in choosing what type of, aid or service you provide, you do have to take the individual's preference into consideration. Your obligation also extends to companions of the individual with the disability. Okay, so if the request is coming from a family member, you have to attend to that in the same way as if it was coming from the individual with the disability. However, you cannot rely on the companion for the communication. You cannot rely on them to serve as an interpreter. You cannot communicate with them and bypass the individual with the disability. Okay, and finally, you cannot charge for these auxiliary aids of services. They must be provided free of charge. We are running low on time, so I will provide the CLE code at this point for anyone who has to drop off. It is SS2554, and I'll just repeat that one more time. It is SS2554. Okay, if we can move on to the next slide. Okay, all right, here, our favorite topic, service animals. And I'm just going to breeze through this. So under Title III of the ADA, a service animal is a dog, okay? It is a dog that is individually trained to work or perform tasks for individuals with various disabilities. So think about, a seeing eye dog or a dog that is trained to pull a wheelchair, for instance. Other species of animals are not covered under Title III, except for miniature horses, which we will cover on the next slide. So under Title III, miniature horses are essentially offered, the same treatment as dogs that serve as service animals. Okay, so these animals, these dogs and miniature horses that qualify as a service animal, must be allowed into places of public accommodation, and they must be allowed to go anywhere where a member of the general public would be allowed to go. So, a doctor's office, waiting room, if it's an operating room, probably not. But most places where members of the general public could go, you have to allow individuals with qualified service animals to also go to those places. With regard to miniature horses, you are not required to provide food or special care for them, and there are these 4 reasonableness factors. They must be housebroken, under the owner's control, they have to meet certain size requirements, and they cannot compromise legitimate requirements that are necessary for safe operation of the facility. If we could just move on. Okay, so a key distinction here between service animals and emotional support animals. Animals whose sole function is to, just provide support for an individual's emotional well-being, they are not service animals and they are not covered under Title III of the ADA. They are covered under other laws, for example, the Fair Housing Act, but not under Title III of the ADA. Next slide. Okay, so there are 2 questions that you can ask individuals who want to bring a service animal to your facility. 1, is the animal required because of a disability? Answer, most likely yes. 2, what work or tasks has the animal been trained to perform? The answer might be, they've been trained to pull the wheelchair that I use, or they've been trained to retrieve medication that the individual may need. You cannot ask these questions, or you should not ask these questions if the need is obvious. So for instance, if you actually observe the dog guiding an individual with a visual disability, or pulling someone in a wheelchair, you should not ask these questions because they're already answered. The need is obvious. Okay, you may not ask for proof that the animal has been certified, trained, or licensed as a service animal. These types of certifications are useless anyway and can be easily bought on the internet. Next slide. Okay, these are some other questions that you should not ask an individual with a service animal. You should not ask questions that are probing into the nature of the disability that they have with documentation or otherwise. You may not charge a special entrance fee, and you may not request that the service animal demonstrate or perform their training. Okay, you just want to be thinking about those 2 questions. Is this animal required because of a disability? And 2, what work or tasks have they been trained to perform? Next slide. Okay, there are certain, again, limitations for permitting a service animal. 1 is if the animal is out of control and the individual is not taking corrective action, if the animal is not housebroken, and even in this scenario where you cannot permit the service animal onto the property, you still should give the individual the option of remaining at the property without the service animal, or leaving and returning without the service animal. Okay, just a note here, allergies and general fear of animals are not valid reasons for denying access or refusing service to individuals with service animals. There is always a consideration, though, for whether the animal poses a direct threat to the health or safety of others. This is a complex case-by-case analysis. Next slide. Okay. With regards to Massachusetts law in particular, offers the same protections as Title III of the ADA with the additional protection for service animals in training. So service animals in training are protected to the same extent as service animals that have already been trained. And just as we've covered with Title III, you may not ask for proof of or documentation of the animal's training. Just a quick note here, in the context of employment, these regulations apply to public accommodations when serving members of the public, but there is a separate analysis when you're making a determination as an employer and determining whether an employee can bring an animal to their place of work. So you still have to conduct an analysis within the reasonable accommodation framework. So just a consideration there that the answer in the employment context may be different than the answer here, where the regulations are pretty clear and well defined. Okay, so I think that brings us to the end.
Thank you, everyone. Our contact info is here, and to the extent you had questions, we obviously didn't have time to get to them, but we will follow up with you. Thanks again for joining us.
Thank you.